Hello, welcome back to China Manufacturing Decoded from Sofeast, special episode 148 today, because there's not only myself, Adrian, from the team, but I've got our CEO, Renaud, with us, and also our head of new product development, Andrew, as well. So hello to both of you.
Yeah, hello, Adrian. Thank you.
Yeah, hi. Interesting topic. Yeah, go ahead.
It is an interesting topic today, and that's why we've got reinforcements with Andrew on the recording as well. And what we're talking about today is basically when we need patents for new hardware products, and new hardware products in particular, because this is something, of course, that we work with quite a lot at the Sofeast group. But in general, this is the sort of question that people who are developing new products tend to ask, because they think, well, I want to protect my IP, so it follows that I should get a patent. However, it may not necessarily be the correct action at an early stage. There are benefits and drawbacks. So what I'm looking to do today with both of you is to go through a little bit about IP protection, which we've spoken about and written about before, of course, but also talk about when would we need that patent, what sort of patent would we go for, what are the costs, where do we file it, and really go into detail. And hopefully the listeners will be left with a much better idea of when or why to go get that patent or other actions to take. So how does that sound?
Right. Thanks, Adrian. So this is a topic where there's a lot of opinions, and people who develop, who are designing a new product, and they might speak to maybe an IP lawyer who might say, well, you think your product is unique? Well, yeah, of course, you need to protect it. How are you protecting it, right? And you get to do a patent. And then they talk maybe to some investors, and some investors will say, oh yeah, if there's a patent that's filed and granted, of course, there's a higher valuation. So there's the entrepreneur is thinking, well, that's really something we should do. And then on the other hand, there's people, let's say, who come more from the business side and have done it and seen it many times. And sometimes some of them even say, well, this is just pissing money, for nothing. It's most of the time is useless, right? So there were some people on Shark Tank, for example, saying that, and so on. Okay, so basically what we're trying to do today is bring a little bit of structure to how to think about it, right? And really, the first thing we should say is that we are not lawyers. So this is a discussion from the business point of view. Business only. Don't follow this as legal advice, okay? And the very first thing we should reiterate anyway, because I think it's always good advice, is that if you have a concept for a new product, and or even if you start to design it, well, that's great. When you disclose it to people, especially, let's say, people in the industry, right? Not potential customers. That's not really the problem usually. The problem is more people in the industry, like maybe an industrial designer, maybe a potential manufacturer, these kinds of people, or maybe a potential distributor, in someone that you might do business with. You get to sign an NDA with them, okay? Because if you fail to sign an NDA with at least one of them, well, later maybe you file a patent, and then this might come back to really bite you. Oh well, it was disclosed without any protection, so that might cause you a lot of trouble. So anyway, it's always a good thing to get people to sign NDAs, except I repeat, potential customers who are really not in the business, in the industry, right? Because you really need to get their feedback. So do not let that kind of fear of being copied hold you back. You need to talk to people. You need to get some feedback on your idea, on some early mock-ups and so on. It's extremely important. And the second thing is, if you don't want to be copied, or at least not too early, don't put it on YouTube, don't put it on Kickstarter or Indiegogo, right? You know that when you do that, the clock has started ticking, and if you're out there without much protection, then yes, it's easier. You make it easier for people to copy you. Okay, so these are the first two things, the very, very basics that we should mention first. Does that make sense, Andrew? Do you have
Oh,
any other basic advice like that?
oh, absolutely makes sense. Yeah, I mean, that is one of the, I would say, rule number one in patent trials. I mean, you really don't want to put it out there too early. Then, once your ideas is stolen or taken away, it's going to be hard to catch up. One of the things that I was thinking I should perhaps bring it up to our listeners is, before you do anything, you really need to determine what type of intellectual property protection do you need. For example, because I remember when I was younger, I created a document and I called it my invention. It was a process and a procedure. And then I realized that no, you can't really patent that. It's more like a copyright and trademark type of situation in that case. So I think it's important for the inventor to go do some research, determine whether what he has invented is more like copyrightable, or is it a patentable trade secret. Do some research on that, go through some inventor resources online, maybe check some lawyers like you mentioned. So I think that is the first step.
Right. No, absolutely. Yes. It's not just about patents, as you mentioned, copyrights, trademarks, and so on. We're not really going to these ones, but not everything can be patented. And there's several types of patents. I think we should also talk about that.
Yeah.
Basically, the main two types of patents, from what I read here and there, it always comes back, is design patent or utility patent, right? So design patent, if your product has a certain look, well, you don't want competition to use that look, right? That same appearance. It's really what it looks like. And you're not really, if you come up with a great new way of, I don't know, of a great new kind of, let's say, wheelchair, okay, for handicapped people, what is really going to be the differentiator? Is it what it looks like, or is it the mechanism behind it and how it works? Well, if it's a great new one and you don't want competition, it's probably not just the way it looks, right? It's really what it does, how it solves the problem better. This kind of patent doesn't really protect you that much, and it's kind of easy to get around. A competitor would do something that does the same thing but looks a bit different, and that's fine, and that's really easy, right? So when you see, oh, there's a patent, what kind of patent is it? Because design patents are kind of weak. In most cases, anyway. In most cases, okay. Now, when BMW comes out with a new sport car, and they don't want some other manufacturer to come up with something that looks too much the same. That's very important to them. Okay, but usually, let's say for consumer electronics and so on, this is kind of weak. And then you have the utility patent, which is what it does. Now, this is harder to get because you really have to show that the mechanics, the function, the way it does the work that it does is unique, is new. And it really is not easy to get that kind of patent. But then once you get it, this is much more valuable, because if your product does something really new, solves a problem in a better way, and your competitors cannot have the same approach to solving that problem, it's gonna hold them back. Now, depending on the complexity of the product and everything, they might come up with some other solutions, maybe even better, but it's going to hold them back for a while. It's going to make it a bit more difficult for them, for sure, right? So it's very important to distinguish between these two kinds of patents, and basically, from what I understand, there's to file a new patent, you need to do some research and make sure that before you try to go ahead and file it, it's not obvious that there's another product that is quite similar, right? Because it's going to be rejected. It's really not smart to go ahead and spend the money to apply if there's something very close, and then you do the application and so on. And depending on what you do yourself versus what maybe you pay a specialized lawyer to do, and depending, of course, on the fees of the lawyer and the complexity of the product and so on, it might cost you $10,000 to maybe $50,000. These are the kinds of numbers that I read here and there. Sort of usually between these two numbers could be higher than 50K. Okay, but most of the time that's what it seems to cost. So one thing that's really important, and that's for people in the USA that want to sell into the USA market, there's something called the PPA, provisional patent application. Okay, provisional meaning that you don't do any kind of disclosure. You file that PPA. It's simple. It's really streamlined. It's so much cheaper. It's like $200 to $300, right? Plus some homework you have to do. But then it's provisional in the sense that for 1 year, you can decide whether you file for, let's say, a full patent or you just drop it. Okay.
I agree with you. One of the things that are key important aspect of this provisional patent is that allows you to protect yourself early and put that date in. For example, you invented something today, but you don't have the money to really do full patent. You can today do the provisional, and that will protect you in case tomorrow somebody else invented something. They'll say, well, you had done it already first. As I understand, that's the real key point of the provisional patent.
Yeah, it's locking the date, but it's also, let's say, and it's very important not to do that too early. Okay, but let's say do some market research. So, okay, you see, okay, there's something here, and it's very important to do things in the right steps, right? I would not do anything patent-wise before first. Does it look like a good business, right? So do market research. Then what is the technical feasibility? Can we do some of the technical work? Can we get close at least to a final prototype? Then let's look into it, right? Because at that point, hopefully you haven't done any public disclosure, so you still have the option. Then let's say you see that, hey, for that we're going to have to do maybe an Indiegogo or Kickstarter campaign, or we're going to have to start to talk to distributors, or some, I don't know, potential licensees or potential whatever, partners in one way or another. Well, that becomes a bit risky. Do we do the provisional patent application now so that we disclose it, we see if there's good market response, we get 1 or 2 production runs, we sell, we start to distribute, and we see the response from the market. And then if it really looks good, then for 1 year after the PPA filing, we have the option to file for a full patent, right? But we only put $200 or $300 down, right? But for 1 year, you can disclose it to the whole world, and still you haven't had to commit to, okay, let's put 20 or 30K down. Let's hire a lawyer to get it done the right way and so on, right? That is a big big part of the decision. Does that make sense?
Oh, absolutely, it makes sense, and I think that's an excellent way, at least, to get started in the area, because as you know, a lot of people will start something but never really finish it. So it would probably be not a good idea to spend a lot of money right up front, and then here it is 1 year later, you don't even have the drive to finish what you started. So it might be a good idea to start with the provisional, buy yourself time, a year, You lock in the date that you're protected, and then work on it hard and see where you're going to be in a year. And when that time comes in a year that you feel like your product has excelled and progressed a lot, and now you're at a place where you could actually turn this into a money-making product, then I think it's a perfect opportunity, like you mentioned, to go for non-provisional application. I think the key here is whether or not you're going to have a product that is patentable. And at the beginning, almost many people don't have any idea, because the product is the idea, more like the product is more like in the idea phase as opposed to real product phase. And this 1 year time buys them time to turn it into maybe a prototype, functional product. And like you said, do some market studies, put this whole business plan together, and then you'll have a good idea what to do at that time.
Yeah, absolutely. So we're talking about the cost. Actually, one thing that people mention also is that you got to also have the cash to actually use the patent. So you file the patent, and that's the numbers that I mentioned before. But then you need to maintain it. So you need to pay something every year. And then, well, if somebody infringes on it and you feel you need to defend your position on the market and so on, actually you need to prosecute it. And that
some more money.
Yes. And if you have to do that against a big company, well, that is by far the most expensive.
Exactly.
Right.
Exactly. And that's something you need to think about, right? As part of your whole process. I mean, if you're going to be a small needle in a haystack within this, huge amount of competitors, maybe no need to patent, because most likely someone is going to copy anyway, where you're not going to be able to fight with them.
Right. Well, exactly.
This is a good point that you make, Andrew, because we've spoken about patenting before, and oftentimes I think maybe with a hardware startup, for example, the question is really, if the costs of putting a patent in place are so expensive, and it's not just the cost of the initial patent, it's the cost of maintaining it, and then the cost of enforcing it as well, which could be really expensive. Are there alternatives that we can take to gain that sort of protection that we're looking for without such a huge cost, especially when you bear in mind that, as you've said, if we go online and look at a lot of consumer products, there's all sorts of very, very similar ones out there. So maybe it's almost inevitable that something somewhere will be maybe not exactly copying, but very, very similar. So how do we reconcile the huge costs of a patent with that?
Well, I'll let Renaud. You take a stab at this, and then I'll have my opinion.
So there are other ways to make it, let's say, harder to copy. First is you don't really want people to reverse engineer your product, and that's something that is done, so often, right? So you have, I don't know, let's say you have, when Barnes and Nobles and then like the Amazon Kindle, these e-ink readers came out. I don't know, that was maybe 15 years ago now. Well, there's got to be at least 20 different factories in Shenzhen that, pulled it out, opened it up, studied it and reverse engineer, how does these things really work? And then a few years later, you had so many, knockoffs here and there, right? And that's really something that will happen no matter what, but you can make it harder, right? You can you can obfuscate, for example, the firmware. You don't put the source code on right out there. Obviously, I mean, there's ways to do that. You can hide. Maybe you can even grind out the markings of the components. So people don't really know what component is it, where does it come from. Sometimes on the PCBA, they put a layer of epoxy.
Yes, I've seen that.
They they pot it, right? There's all kinds of ways to do that. Okay. And that is one thing. At least make it a little bit harder for people to reverse engineer your product. It's already one way to make it a little bit less likely to be copied too closely. Does that make sense?
Absolutely.
Yeah.
I wholeheartedly agree with you. I think, Adrian, you had an amazing question on that. I think first thing is exactly what you said, Renaud. You got to make it harder to copy. And, one of them is exactly the reverse engineering part of it. But there's also information. So, for example, there could be a product that you have that has many, many features. And it's possible to make that product copied, not reverse engineered by the way, not even maybe exactly the same way, but make a new product that will have same functionality. But where you can win is on the features. You will have features that they just wouldn't know how to put in the product, or and that will be one way your product will be better.
Mm-hmm. Yeah, this anyway, it also comes down to business strategy anyway, right? Don't want to be copied too much. Maybe you go for high volume, relatively low margin, and with a relatively simple product in a way that even a scrappy Shenzhen company cannot really undercut you much.
Yep.
Or do you want to be sort of at the high end of your market? And yeah, people will copy you, but they will always look much inferior because your product is more innovative, is captures people's mind and so on, right? So marketing also obviously and positioning really does help a lot. So you were mentioning, fighting against a big company, fighting against copycats. I think these are the two main fears of people, right? When they're launching a new product. So let's take them one by one. The first case is that you launch a product and then a big company wants to copy it, or they just want to bully you so that you get out of their market, and they are just happy to keep selling the same old product without you creating a mess in their market, right? They will bother you even if you have a patent, right? Yeah, okay, it might make it a bit less likely, but there's so many examples of big companies bullying small companies, even if they have a patent, that it's really not something that will prevent that kind of behavior. And there's two examples that come to my mind, and they are public out there because it's I read about it in some books recently. One is Dyson, when he came out with his dual cyclone, they called it, vacuum cleaner. They were talking with an American company, Amway, a much bigger company at the time anyway, for talking about Amway distributing, or maybe just licensing, actually. I think licensing the product, maybe making it under a certain license and so on. And Dyson sent them some blueprints, some technical drawings and so on. So, okay, here's the way it works. And then when they saw it, the Amway guys say, "Oh well, okay, let's just do it ourselves and let him sue us." But it's a small company, whatever, right? In the UK, let's just take it, grab it, And Dyson sued them, but it took him 5 years, and he nearly went out of business because of all the lawyer fees. And it's so complicated to litigate and show that this is our art and there's no prior art and blah 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 blah. It's so complicated. It's extremely expensive and it takes a lot of time, right?
I think that I have another very famous example, very similar to that, Renaud. You guys, everybody knows Nokia, right? But hardly anyone knows why Nokia disappeared. And exactly that same thing happened. Nokia, I think it was the year close to 2000, is when they were trying to build and design and manufacture their own chipset. Well, they somehow infringe in serious manner to Qualcomm chipset. And everyone knows that Qualcomm had lots of lawyers always watching Nokia and the rest. And there was a massive lawsuit, and Qualcomm won. And exactly at that time is when the judge, I remember reading in the papers, ordered Nokia to close the doors. I mean, close the whole facility. They laid off over 2,500 employees and closed the facility, and they couldn't make any more mobile phones at all right after that. And that was pretty much the end of Nokia. I'm sure that was not the only reason why they completely went out of business, but that was the main division. And I think that really kind of, like you said, they lost so much money, so much reputation that they just didn't think it was worth going back into it.
Wow. Yeah.
That's huge.
This is two big companies going one at the other's throat, right?
Right.
It's yeah. Well, anyway, we won't know exactly why they infringed, and was it that intentional? Probably, right? You would say.
Yeah. Absolutely.
So yeah, this is the kind of games that the big companies play. Even when they have Qualcomm in front of them, I mean that's just dumb.
Yeah, exactly. Cross the street.
when you have when the USA is a huge market, and you do that to a large and profitable and established USA company. I mean, it is just dumb. And another one I read about recently was Nest versus Honeywell. Honeywell was very happy with the, sort of owning the thermostat market, and then Nest came up and it's smart, and it does this and it does that, and then Honeywell was like, who is these guys? Let's just sue them and pretend that they infringe on our our beta, that they copied us. And it took them so long that it was not even settled by the time Google acquired Nest. It had to be settled after that between Google and Honeywell. Anyway, very expensive, and it's really painful. So that's why the patent needs to be, there needs to be research on prior art and the filing, to get it registered and actually get it passed, right? Really get it granted. But then you need to maintain it over time. That's also not a trivial amount of money. And then you need to defend it. And again, that might be the most expensive of all. The second thing that people are worried about after big companies bothering them is the copycats. And people always talk about China, and well, it's a fact that there's a lot of companies, especially around Shenzhen, that monitor what comes out on Indiegogo, Kickstarter, YouTube, whatever. They talked about it. It came up on TV. Okay, what is it? Oh, there's good reception. Okay, we can find a way to make it at half the price. At half the cost, and sell it for maybe a third of the price, right? It's just amazing sometimes. It's not as nicely finished, but it's much cheaper, and they have ways of getting some exposure. It is really can be very painful. Several of our clients got in trouble with this, and several went out of business. It's very, very painful. Okay. So the thing is, if you have a patent, and actually most of these clients that I'm thinking of had a patent or had a patent application underway, okay, and went out of business anyway. So if you have a patent, the problem is you put 20, 30, 40K US dollar into that, right? So that money is no longer available for you to grow. And you're putting your product on the market, and you don't have a lot of fuel to push it, right? In marketing channels and so on. And then you have this Chinese company that develop it in a simple way, not so great, but it's much cheaper. And then you have people maybe who covered your product earlier who get free samples, and then they do, this cheap Chinese product versus that brand that we covered 3 months ago for their Kickstarter campaign, it does the job. It's half the price, but it does the same job. Ouch. Very, very painful. Okay.
Right.
And even if you have a patent, and let's say your patent is already granted, let's say, right, which is often not the case, what are you going to do? It's a Chinese company, right? Your patent, usually, your patent, you need to register it in the main countries of sale of the product, right? So if it's a pure US company, you're targeting the US market, you go for a US patent. Very often also a patent for Europe makes a lot of sense, more often than China, because if you don't plan on sitting in China, it doesn't make that much sense. But the problem with these Chinese copycats is that they're in China, not so easy to litigate against, and you don't have a patent there anyway, so you can't really do anything against them in their home market over there in their home country. And very often they drop ship it to your country. They're not even located in your country, right?
Exactly.
So, yeah.
And you just read my mind. That's what I was just thinking about. The fact that, if someone actually has, patent in China, they're not going to know what's happening with their products. If people are selling it all over the world, and it may be actually infringing to some other products in US, but when someone is just drop shipping one unit, well, how do you go after that one guy, right? So it's a very tough situation in a global when you look at it globally.
Yes, and the game that these companies are playing, the copycats, is that ideally there's a company somewhere in the US or in Europe that came up with a nice idea, get some nice market feedback, and ideally the copycat will just steal the market from under them and drive them out of business. And then after that, who's going to sue them? After that, they can go into more traditional distribution channels. Nobody's going to use the patent anyway because it was granted to a company that went out of business, right? So that is really very, very painful. And that's why the best protection is first to survive, right? To make sure that you survive in these cases, and don't spend your capital on something that will not help you survive the first year, right?
So what you're saying here, Renaud, is for a hardware startup with a really cool consumer product, for example, that, let's say, $20,000-$30,000 US that would be spent on a patent would be potentially better spent on, say, advertising and having really great marketing and building up that momentum.
Right. Oh, yeah. Oh, and it's 20 or 30 or can be $50,000.
Sure.
Not exactly
Absolutely.
Sure. Different people in different countries, right? But the numbers can really be relatively high.
There's one more thing that I was going to bring it up, Renaud, and what I think it will be an important topic or something that inventors need to be aware of. And that is when you have great idea and you actually have a prototype that is functioning. There's nothing like it in the world. However, you have no patent, you have no protection absolutely whatsoever. And all of a sudden, an investor shows up and then they ask you all kinds of things and you're motivated by the fact that they're really interested. They got the money. And then you start giving the pitch. And guess what they're going to say at the end? I don't think this is a great idea. I'm sorry, but no, I'm not going into this. And, I don't know if you guys remember the story of one of the big U.S. companies. I'm not sure if it was Ford or GM. It had to do with the windshield wipers. The inventor actually went to give a pitch to GM or one of these guys. You'll have to forgive me. I don't know exactly which one.
Right.
They turned them down and they said, no, that absolutely won't work. So a year later, the exact design was applied to a car. And this guy was poor, no money. and they made a movie about this. He went back to, the court and actually created, basically had a lawsuit against this huge company, one man, defended himself being basically his own lawyer. And surprisingly, he won.
Mm-hmm.
Now, that was one case out of many that won. I don't think that will ever happen again, but it's an advice to inventors. You probably don't want to go give that pitch. They'll say they don't like it. They say, your idea sucks. But in reality, they'll probably go and with their money, they'll make it happen.
Yeah, you gotta be careful. You get to get people to you get to take your precautions. I would say it's always a good idea anyway to talk to a lawyer, and the advice would be different for B2C products versus B2B. If it's B2B, and especially if you try to sell it to 1, 2, 3 big companies that would buy a lot of units, well, you get to work closely with these people. You can't just keep your idea close to the vest. You get to open up to a point, right? So how do you do in that case, right? That's tough, and we're not really going to cover that today. But this is the kind of questions that people need to keep in mind. But when it's business to consumer, wow, that's really different. You're really more worried about your competition, right? The dynamic is quite different. Now, I think a simple rule of thumb is if you really see it's a home run, go ahead and file. Okay. But if you really see you have a home run, at the same time, get some investors to shell out some cash and make sure you still have enough cash to push for marketing, distribution, everything, get the production going and so on, so that you go through the first year without any risk for your business. Okay. And there's a number of ways to see if you have a really, a home run, but the problem is without disclosing it out there in public, it's a little bit difficult. Now I'm not sure that's really an open question. I don't know. I should ask a lawyer about that. There are software like prelaunch.com. I saw them at the CES again and some others. They actually, if you do some advertisements relatively targeted in Facebook or in Google, and you try to get some feedback and you try to push for some early sales over there without putting it on Indiegogo or Kickstarter or YouTube or anything like that, does it count as a public disclosure? Well, maybe, but who's going to be able to gather the evidence that you did it, right? Because, most likely the people that you are targeting and touching this way are not in the business, related to your company, to your product. They're not going to collect the evidence that you're running this kind of advertisement and disclosing some information, right? And there's no trace after it's gone. So this is probably a safer way of doing market research and really collecting data that prove to investors, hey, look, there is a strong market response. This is a very hot product. Let's capitalize this business properly so that we can file a patent. But really, I would say never do it the other way around. Put your cash first into a patent and then go to investors. And this to me doesn't make much sense, right?
Renaud, you mentioned something that kind of triggered another thought, and you were talking about if your product is not. You mentioned that if your product is a home run, but what if your product is not a home run? It's a great product, maybe nothing like that exists, but eventually will be day-to-day products, such as, for example, mobile phones, right? Or a hamburger. I mean, you can go to many restaurants and have a hamburger. It won't taste like McDonald's. It won't taste like Burger King. They all will be different, but it's a hamburger. You'll make a living. You'll have a product. You'll have a company, and maybe you'll come up with a new form of a mobile phone. For example, I think you all have heard that Elon Musk is coming up with a new phone called Pi.
Really?
No, you haven't. Oh, this is an
No.
amazing. Yeah. It's a new phone, mobile phone. It's going to work with satellites, and it's already satellite ready. And then it's got a lot of amazing features that definitely some people call it Apple killer. Now, the point is, now here it is a company that is going to create to come up with a mobile phone. I mean, mobile phone is not an invention, right? It's just new features added in there that he believes that nobody else would have. And this a very functional phone, you could be on top of the mountain and still have internet, right? So my point is, you may not hit the home run, but at least you'll have a product that has quite a bit of differentiation, like you were talking about marketing aspect of it, that perhaps might be worth giving it a try and being just another product out there, another option, another choice for the consumer.
Sure.
Again, going back to the strategy, right? The role in many cases of the version 1 of a new product is, in most cases, right, is not to establish a new technology, a new way of doing something that will be the basis for a business for the next 50 years, right? In most cases, the role of the V1 is just to put something out there, collect feedback from the market, right? And it's a basis for version 2, which should fix the main problems, okay? If V1 is at least moderately successful, right? So, again, let's look at the two kind of scenarios. The big company wants to bother you. Well, you put out your version 1 is so tiny, they don't even notice you. They don't care about you, right? So when are they going to start to care about you? When maybe you put out your V2 or your V3 and it's good and it starts to get a lot of attention in their industry, then they're going to start to look at you. So in that case, V1 is probably not when you need a patent anyway, right? Except in very specific, like for example, Dyson, most people in the industry thought it was impossible to have a vacuum without a bag. He did a proof of concept. It's possible. He made it work. That's a very specific case. Okay, large market, very interesting innovation. Okay, but really, most new products are not in that category, right? Okay, then let's look at the copycats. The copycats, and this is specifically the China copycats. Your patent, let's say your main market, for example, is the European Union, and you have a patent there, and all you can do then is prevent them from having distribution there. Okay. Now, if you also need to bother them in their home country, you also need to have a patent in China. The costs just pile up. And if you do that in China, well, you go after them and they're going to just, close one company, reopen another company. I mean, things are most of the time not going to be very easy really to go after them, right? So when are these copycats going to try to have traditional distribution? Probably not at the very beginning, because at the very beginning, again, they're making one batch and they're just going to do online kind of advertisements and placements and so on, and they're going to drop ship it. So at the very beginning, there's not much you can do against them. And they will, to my knowledge anyway, they will usually not try to patent the product. Okay, they just want to go and, invade your market, steal it from under you, you abandon it, and it's just for them to grab, right? That's what they want, usually. So at the very beginning, a patent is not going to be so useful again, right? So be very, very careful about a patent for version 1 of the product. it's not that useful. Okay.
Great.
A lot of people will say, well, it's nice to mention in your marketing materials that it's patent pending or that it's patented. That might be true, but I'm not sure it's going to cause your sales to grow 50%, right? What is the tangible benefit of that? It's very difficult often to put the finger on it. Even when trying to get some distribution deals and so on, the distributors, all they want to see is, okay, can I move this thing? Doesn't take too much space in my store. It's, I know where to put it, complementary to these other products. Are they going to give me some support in sale in the stores to get it moving? Can I negotiate good payment terms? That's what's really important for them. Do I have exclusivity on the market in these areas and so on, right? I don't think that's mentioning that there's a patent, and especially patent pending, because you're not sure if you're going to really have the patent in the end. I'm not sure it's really that important. What do you think?
No, I totally agree. I think that is one of the dilemmas of the situation when you have a great idea and you're trying to patent it. You're not sure whether you should go for it. You're not sure if you're protected when you patent it. And you're not sure that if you don't patent it, how much you're protected. So, which is basically none. I think that's one area that I think it's still a big question in many people's, who actually apply for patent.
Right. And then another, I think that as a closing thought, if you patent your product, especially for a utility patent, you are basically telling the world, you are explaining to the entire world, here is how it works, right?
Exactly.
You're making it public. Anybody, all your competitors can access the patent documents and see, the technical drawings and things. Oh, okay, this is how it works. This is what they say is unique. Okay. And then they can start to think, all right, how can I go around that? Or, what countries do the patents apply to, and where can we already make the same thing, but they're not protected, right? So there's something to say about staying a little bit under the radar again, as I mentioned, not when it comes to market research. You need to talk to people and get feedback and get some sales and so on, but from the rest of the industry. And there's really something to say about, the specific case where there's deep technical work. I think just before the call, you mentioned something about GoPro and something that they did right that really helped them, be relatively unique for a long period of time.
Yeah, that's right. So, one of the unique thing about GoPro, which was one of the best IPOs at the time, was because of the fact that they were doing that for over 7 or 8 years before anyone even find out about them. For a long time, I had no idea what the word GoPro meant. No one knew that they're going to take the whole camcorder business. We're talking, companies such as Sony, which were number one in camcorder. And here it is, GoPro, small company, just came out of nowhere and took them by surprise. And I think one of their success was exactly what you were saying. They kind of moved slowly. That they didn't do huge advertising until they actually started going IPO. And then once the product started becoming a lot more sophisticated and complex, and they started doing their own algorithms on the photos and writing their own codes for creating their own chipset, that's when the product became extremely famous and extremely complex. And that's when they decided, okay, maybe we'll start going IPO and patent and all that. But up until that point, no one even knew what GoPro was. And I think the fact that they were 8 years ahead of, even Chinese or whoever that wanted to copy them, they wouldn't catch up with them. They were way, way ahead with multiple products, multiple revisions of the product, with huge $1 billion worth of investors backing them. So they were about to, open and go places that no other could if they tried to copycat. And there were some copycats, the Chinese versions of the product, terrible photos and so forth, and really never succeeded.
Right. So something to say about not forgetting to actually make a great product.
Exactly.
I think that's a great closing remark, right?
Exactly. Yep.
Excellent. Well, that's a really in-depth view of patents and when they might be necessary and what other options we have. Certainly sounds expensive, so I can understand why this is an area that hardware startups especially are concerned about, because it's a lot of money for a hardware startup. So I hope that for the listeners, that gives you a little bit more grounding on when the right time is. We have talked about patents before and IP protection in particular. So as ever, I will leave some links to our content in the show notes. Thanks everybody for listening, and thank you, Renaud and Andrew, for coming on.
Hey, thanks a lot,
Adrian.
guys.
Yep. Thanks, Renaud.
Thanks again for listening to this podcast brought to you by the Sofeast Group. We're on a mission to provide you with everything you need to manufacture effectively in Asia, including inspections, auditing, new product development support, contract manufacturing, 3PL warehousing and fulfillment, and much, much more across Asia's key manufacturing areas. Visit us at sofeast.com, that's SOFEAST.com, to learn more and get help. If you've enjoyed the podcast today, please do rate, review and share, because it will really help others discover us too.